Welcome to Landmark Chambers webinar, Possession Proceedings, What to Expect When the Stay is Lifted. We are delighted so many of you are joining the session today. At the moment we've got 243 of you, and we hope you will find this presentation and discussion useful and informative. Before we begin, a few housekeeping points. All of your microphones are muted, so you will not need to adjust your settings. Your videos are also automatically turned off. So if you have it turned on, please can you turn it off? We welcome questions throughout the session via the chat function. You will hopefully have that at the bottom of your screen. And we will try and answer as many questions as possible at the end of the presentation. The webinar will be recorded, and both the slides and the recording will be uploaded to our website after the presentation. If your connection is lost at any point, please do rejoin the webinar via the original link. My name is Evie Barden, and I'm joined today by Tom Morris and Nick Grant. We were going to be giving you a whistle-stop tour of what had happened in the world of possession proceedings over the last 6 months, and also where we are now. But as with this topic, not a day seems to go past without something new and exciting happening. Shortly before the last version of this webinar, which our colleagues Brooklyn, Miriam Sietler and Kimberly Zier did, the stay was extended on possession proceedings until the end of September. Today, we've also had our own excitement. Just as we were all sitting down to have our respective prep sandwiches, we got a very exciting email in our inboxes, which was that the Master of the Rolls' working group on possession proceedings had released a document setting out what the overall arrangements for possession proceedings would be once the stay is lifted in 5 days' time. Those are referred to as the overall arrangements. So we will do our best to summarise its contents, what to watch out for in those arrangements, and what it doesn't cover or say throughout the course of this webinar. We're also hoping to cover off some of the other developments which are now not so fresh off the press, such as modifications to the notice periods for various notices such as Section 21 notices, as well as reactivation notices. But before we get on to what happened in the last few weeks, Tom, why don't you remind us how we got to this point?
Evie, I can do just that, because earlier today, as it happens, I prepared some slides bringing us all up to date. The starting point, of course, which everyone will be very familiar with, is Practice Direction 51Z, which set all of this off in March, and this came into effect on the 27th of March this year, and it stayed all possession proceedings for a period of 90 days. That was then extended further, the period of the stay, to the 20th of September 2020 by a new rule introduced into Part 55 of the CPR, which is Rule 55.29. And just one note at this stage, Section 82(1) of the Coronavirus Act 2020 provides that no right of re-entry or forfeiture under a business tenancy in case of rent arrears is enforceable by action or otherwise before the 30th of September 2020. It's not quite clear how that works with the separate stay in Rule 55.29, but it would seem very prudent at this stage not to take any steps in commercial forfeiture proceedings involving rent arrears until after the 30th of September 2020 to avoid coming a cropper with that funny 10-day overlap period. That takes us on to the next slide. The starting point in all of this has to be, I think, what is the effect of a stay? And the glossary to the CPR very helpfully tells us that a stay imposes a halt on proceedings, apart from taking any steps allowed by the rules or the terms of the stay. And it says that proceedings will be continued if the stay is lifted. And the White Book commentary adds to that, the making of a stay imposes a halt, not only upon proceedings, but also upon the expiration of any time limit in those proceedings which had not expired when the stay was imposed. And on to the next slide. The next question then is, well, what in fact is caught by this practice direction and what has been stayed. And the starting point again is that all claims which were brought initially under Part 55 of the CPR are caught within the scope of the stay, regardless of whether they are commercial or residential. It also bites on claims for relief against forfeiture brought by tenants, where that relief amounts to a claim for possession, which is brought under Part 55. We seem to have gone forward one slide. I don't know if we can go back. Thank you very much. It also includes claims where a counterclaim has been made for a possession order in the proceedings. That brings all of the proceedings within the scope of the stay. It also applies to appeals against possession orders. And a case which I've been involved in, it also bites on proceedings where liability has already been determined in a split trial and a possession order has already been made, but the determination of damages has been put off to another date. Because the original proceedings were brought within Part 55, they are automatically stayed, even though a possession order has already been made, and so the determination of damages gets kicked off until the stay is lifted or expired. And also, the effect of the slightly unusual decision, I think, in TFS Stores, in which at least one of the judges in the Court of Appeal dissented, the stay also bites on claims where the parties are agreed that a possession order should be made to give effect to a judge's ruling, even though their claim, when it was initially issued, did not include a claim for a possession order. So standing back from all of this, it's clear that the stay is very, very wide and that a lot of proceedings, including some quite unexpectedly, are actually caught by the operation of this stay. So next slide, please. This brings us to the exciting bit, which is what happens after the stay has been lifted or expired. And time essentially starts to run again from the moment when the stay is lifted or expired. And this is what, or how Lord Justice Coulson explained it in Grant and Dawn Meets. He said that when the stay is lifted or the stay expires, the position as between the parties should be the same as it was at the moment that the stay was imposed. The parties and the court pick up where they left off at the time of the imposition of the stay. And we know from the Court of Appeal's decision on the practice direction in Arkin and Marshall that where the parties have put in agreed directions, which are not caught by the stay, and a court order has been made embodying those directions, time does not actually start to run under that court order until after the stay has been lifted. So even if you have a court order that says you must put in a witness statement by this date, as I'll explain in a second, time doesn't start to run, and the date needs to be recalculated from when the stay is lifted. So next slide, please. So how to recalculate time? Well, in Grant and Dawn Meets, the Court of Appeal told us what the conventional analysis is and how it works. And what this means is that to work out your post-stay time limit, you first of all calculate how much time the parties had to take a particular step before the stay was imposed, and you deduct from that the number of days which had expired before the stay was imposed. Now that gives you the number of days which the parties had left under the time limit before the stay was imposed, and what you do is you take that amount of time and you add it on to the end of the stay. So that is how much time is left to run when the stay is expired. And so to calculate your new date, you take the date on which the stay expires and you add on that extra period of time which still had to run before the stay was imposed. So on to the next slide, please. Now, the legal position is complicated slightly by Practice Direction 55C of the CPR, which in fact modifies Part 55 during what is called the interim period. And the interim period runs from the 20th of September 2020 to the 28th of March 2021. And this identifies two different types of stayed claim. The first of those types is a claim which was brought before the 3rd of August 2020. And the second type is a claim which is brought after the 3rd of August 2020, or in which a final order for possession has already been made. So the first type, which are claims brought before the 3rd of August 2020, are actually caught by paragraph 2.1 of Practice Direction 55C. So if we can move on to the next slide. So this is what happens. This is the effect of the stay ending in a claim which comes within paragraph 2.1 of Practice Direction 55C. What happens is that the practice direction says that the claim is not to be listed or relisted or heard or even referred to a judge until a reactivation notice is filed and served, unless, of course, the court directs otherwise. Now, Evie is going to come on to talk about reactivation notices shortly, but I'm just going to note at this stage that where, in a case to which paragraph 2.1 applies, where case management directions were made before the 20th of September 2020, i.e. before the stay expires, it's very important to note that the reactivation notice must, this is mandatory, be accompanied by a copy of the last directions order, together with new dates for compliance, taking account of the stay before the 20th of September 2020. So in other words, what the practice direction tells you to do is to do the maths on behalf of the court. In other words, you have got to work out when the actual dates for compliance are having regard to the stay, even where an order has been made prior to the stay. You also have to set out a draft order setting out additional or alternative directions, including proposing a new hearing date, or, if you think this applies, a statement that no new directions are actually required and that an existing hearing date can be met. And this is all mandatory where paragraph 2.1 applies and you've got case management directions which have been made before the stay expires. Next slide, please. So there are a number of implications from this, which I think it's going to be very important to note. I can see lots of opportunity for people to come unstuck on some of this. The first point is that time starts to run from the date that the stay is lifted and not the date that the reactivation notice is filed and served. And it follows from this that the dates are to be calculated in your order from the date of the end of the stay and not the date of the reactivation notice. Another very important thing to note, unless the court orders otherwise, any trial date which has been set prior to the 27th of March, i.e. before the stay, will be automatically vacated and the case automatically stayed unless the party can comply with the requirements of the practice direction not less than 42 days prior to the hearing date. And another way in which the practice direction automatically stays things again, even after the stay is listed, is that if you don't file and serve a reactivation notice in a paragraph 2.1 claim before the 29th of January 2021, the claim is also automatically stayed. Now, the practice direction tells us that in neither case is this a sanction, and all you need to do is to put in an application to lift the stay once it's been reimposed. However, it is important to note that where the stay is, or where you're applying to lift an automatic restaying before the end of the interim period, i.e. before the 28th of March 2021, all of the requirements for reactivation notices will still apply. So along with your application to lift the stay, you will also need to put in a reactivation notice. I've used the word or the term reactivation notice a number of times, and I know it's the most exciting thing about this for a lot of practitioners. So at this point, I'm going to hand over to Evie, who will give us a bells and whistles tour of what reactivation notices are all about.
Thanks very much, Tom. Before I come on to talking about the meat of what reactivation notices are and what they need to contain, we've had our first question on the chat function, which is pertinent, and it's about whether reactivation notices are necessary where there's been an appeal or where someone is seeking permission to appeal. Tom, Nick and I were discussing this before the webinar today because there is some ambiguity, unsurprisingly, in practice direction 55C. One might think instinctively, well, a final order has been made, so there's an express carve out and you don't need to file and serve your reactivation notice. I think that is probably the wrong answer, actually, because of paragraphs 2.2 and 2.3, which talk about requirements for reactivation notices except in cases of appeals, i.e. there are specific things you need to do or your reactivation notice needs to contain, but you are exempt from including those specific points such as an up-to-date rent arrears statement where there is an ongoing appeal. So I think you do have to file and serve a reactivation notice if you're appealing a final possession order. And more practically speaking, if you've got an appeal where the appeal has been stayed because of the stay in 55.29, how are you actually going to get it listed? So first, I think as a matter of principle you do, but practically also you probably need to write to the court in any event. But what does your reactivation notice actually need to contain? So I've got a sort of example on the screen. It's not one I've drafted, it's one that I found online from the British Landlords Association, and I've seen a number of other examples flying around online. One thing that you do get out of the Master of the Rolls as working group on the arrangement for possession proceedings is that there will be a pro forma available from the court service. I've not yet found it online, so whether you'll have to make actual inquiries of the court service or whether it will soon be on the MOJ website, I don't know, but watch out for that. Apparently it will be with us this week at some point. That being said, there's no prescribed form, so you don't need to use the pro forma. You can develop your own reactivation notice, provided that it is a notice in writing which sets out that you want the case to be listed, relisted, heard or referred, and complies with the requirements of PD 55C. So what does it need to contain? Well, it will need to confirm that the party filing and serving wants the case to be listed, relisted, heard or referred to a judge. Except where you've got an appeal, it will have to set out what knowledge the party that is filing the notice has about the effect of the coronavirus pandemic on the defendant and their dependents. And also, except where you've got an appeal, it will have to, and the claim is based on rent arrears, it will have to provide with it a notice, provide with the notice an up-to-date rent account for the last 2 years. So looking at this example on the screen, things that I think it doesn't contain, for example, it doesn't say that you want that the claimant wants the claim listed, relisted, heard or referred to a judge. I don't think it does need to say, as it does, that the claim be reactivated with immediate effect. The effect, as Tom has said, of the stay being lifted is that the claim is no longer stayed. So you don't need to expressly say that the claim be reactivated. In terms of paragraph 1 of this example notice, if you're wanting the court to issue directions, as Thomas said, you have to attach with your reactivation notice the directions that you want made. Paragraph 2, a copy of the notice has been served on the defendant and a certificate of service is attached. I don't think it's a bad idea, as this suggests, to exhibit your evidence of service of your notice with whatever you file at court, because it is a requirement that you file the reactivation, that you serve the reactivation notice as well as file it. But paragraph 3 is probably the real kicker, because it goes to what knowledge you have. And I don't think that this paragraph 3 is sufficient, because it doesn't set out what knowledge the claimant actually has. And that's the important thing. It's what knowledge the claimant actually has. There's no requirement in the practice direction for you to go away as the claimant and make inquiries, although you might be well advised to do so. Any prudent claimant might think it's a good idea to have that information to be engaging with their tenants or mortgagees. But you're not actually required to do so by the practice direction. I think it will link into something Tom is going to talk about later, which is COVID-19 case marking. But it's not sufficient just to say we have made inquiries and we'll file that when we have that information. If the answer is at present you don't know of any effect, that there has been any effect of the coronavirus pandemic on the defendant and their dependents, that's what you ought to set out. And then the last thing is, does it need to contain a statement of truth? My view is it doesn't. There's no requirement in the practice direction, and it's not one of the express categories in part 22, so it doesn't need to, albeit that I don't see any problem if you do decide to. A final thing to note, and it's made clear by the new arrangements that have been published, reactivation notices apply equally to accelerated possession claims as well as claims which have been issued in the normal Part 55 procedure. So don't forget to do them for those claims, even though you don't necessarily want those to be listed for a hearing. You do want them to be referred to a judge. The other thing you might be interested from the practice direction is the notices under paragraph 6.1, which apply to claims which were brought on or after the 3rd of August. You don't have to file a reactivation notice for those, but what you do need to do is bring to the hearing 2 copies of a notice which confirm if there are requirements for you to have complied with a pre-action protocol, that you've done that and how you've done that, but also setting out what knowledge you have on the effect of the coronavirus pandemic on the defendant and their defendants. And you've also got to serve that notice on the defendant at least 14 days before the hearing. The working parties' arrangements don't really say very much further about reactivation notices than what I've already said. But one thing that strikes me from the new arrangements is that there is really quite a lot of emphasis on settlement. I think partly really to go towards reducing the volume of cases before the courts. So there are repeated edicts in the arrangements that we shouldn't be issuing claims without carefully attempting to compromise. And that there is also going to be further guidance geared at making clear what advice is available to defendants, but also how parties should be settling, both in the notices of the hearings that are going to be sent out to parties, but also in separate key points leaflets which will be made available to claimants and defendants. And apparently that guidance is also going to be available this week. And the question that arises, I think, is what is the effect of any non-compliance with that guidance? Should you be issuing without having attempted to compromise, even if there isn't a practice direction that applies to you, a pre-action protocol that applies to you? I think in a case where you've got a mandatory ground, the court can't refuse to make an order. There's no way that the working party's guidance can affect the substantive jurisdiction to make an order. It might be something that is taken into account in respect of costs, although I think most of us will have experienced in any event, even where fixed costs don't apply, courts saying that reasonable costs are fixed costs. So it might not be that different from previous approaches towards costs in possession proceedings. But perhaps the reality is that it's in the claimant's interest, practically speaking, given the backlog that we can expect of cases before the courts. I think, Tom, this might be an opportune moment for you to explain what the listing arrangements are that we can expect to see after the stay is lifted.
Indeed, back to some more very exciting procedural guidance. But before I do that, it might just be worth saying that one of our eagle-eyed participants has noticed that in the last few hours, the government have in fact released their pro forma reactivation notice. Whilst Evie was speaking, I had a very quick flip through it, and I can already, I think, spot a number of ways in which the government's draft doesn't quite seem to comply or match what is set out in the practice direction. For instance, it does not require you to recalculate the reactivation notice does not require you apparently to recalculate the dates, but the practice direction does. So there may be some confusion here, but I suggest that people filling in reactivation notices ought to have a copy of the practice direction next to them, just to make sure that they are not missing anything out that the pro forma notice does. And having said that, we now leap back into the Master of Rolls' overall arrangements. First thing to note is that there have been 3 changes to the usual listing practice. First of all, now a date for a hearing will not normally be given when a claim form is issued. The standard 8-week period between the date of issue and the date of hearing will no longer apply, and there are going to be no block lists anymore for obvious reasons. Instead, according to the overall arrangements, we're told that at least 21 days of notice is required of a hearing after a reactivation notice. But most critically, a new stage has been introduced by the overall arrangements, which is called a review stage, which Nick is going to talk about shortly. The overall arrangements specify that this should take place before a substantive hearing. And it also says that the substantive hearing should not usually be fixed until after the review date and should be at least 28 days after the review date. Now, we're told that cases will ordinarily proceed with a review and then a substantive hearing, but the overall arrangements suggest that this may not actually be the case where existing case management directions provide otherwise. Now, it's slightly difficult to know what to make of this. It seems that, for instance, if an existing case management directive has listed a CCMC, then that CCMC might well go ahead before the review stage. But it also seems likely that at any hearing date listed before a review date has actually taken place, all that's going to happen at that hearing is that the court will give directions which result in there being a review before a substantive hearing. And therefore, to avoid wasting time in going to hearings which don't result in anything, it's probably sensible where a hearing date has been listed to file with your reactivation notice draft directions that either provide for a review to take place 28 days before that hearing, so that that hearing can be treated as a substantive hearing, or directions which relist that substantive hearing in order to allow a review date to be fitted in. And that will avoid that hearing being wasted. The overall arrangements also tell us that certain types of case are singled out for being listed with priority. Now, the cases which have priority include, perhaps unsurprisingly, cases involving antisocial behaviour, domestic violence, squatters and illegal occupiers, unlawful subletting, allegations of fraud, deception, cases of abandonment and non-occupation, and what the overall arrangement describes as extreme rent arrears. Now, we're told that extreme rent arrears, which in the title used to be prioritised, involve either 12 months arrears of rent or, brace yourselves, 9 months rent, where that amounts to more than 25% of a private landlord's total income from any source. Priority is also to be given to claims which have been issued before the commencement of the stay. And one thing to note about this is that commercial cases do not get special treatment under the prioritization guidance, but it seems that they may come within, say, extreme rent arrears cases or cases involving unlawful subletting or cases of abandonment. So it may still be possible for you to get ahead with your commercial possession claim if you can bring it within one of those prioritization categories. Also to note is that claims for relief against forfeiture by a tenant do not at present get priority, even though they may involve some quite considerable hardship on the part of a tenant who's been evicted, where someone has long ago peaceably re-entered. But the guidance does recognise that other circumstances may warrant priority, and rather elliptically, the guidance states that that amplification may be published. Until that amplification is published, it seems that people can take some comfort from another completely new concept introduced into possession claims by the guidance. That is COVID-19 case marking. COVID-19 case marking is not defined in the overall arrangements, but we are told that it is relevant to listing. And it's relevant to listing first because it may identify certain cases which are suitable for settlement, and therefore that might point to them being listed later on. And it might highlight particular urgency in certain cases, which points to them being listed earlier. And any defendant or any private landlord claimant may request that a case is COVID-19 case marked. They may make this request at any stage and by any means, but they must include certain specified information with their request. That's set out in the guidance, and it includes things like details of hardship faced by the party and also the effect on them of COVID-19. The party making the request has to inform all the other parties that they've made that request and presumably serve the request on them, because the guidance then tells us that unless there is an objection, the case will automatically be COVID-19 case marked. If there is an objection, however, by another party, then the court will decide whether the case should be case marked when the file is next before a judge. And so that is the new way in which possession claims are going to be listed once the stay is lifted and they are reactivated. One final note about accelerated possession claims. As Evie has said, these are caught by the requirement to give a reactivation notice. They will still be dealt with by judges on the papers when they're referred to a judge. And the guidance, perhaps a little bit optimistically, suggests that judges will deal with accelerated possession claims on the papers whenever substantive hearing slots are vacated, giving them all of this free time for them to do their box work. The judge to whom the claim is referred may, where the parties agree or where there is no objection, list a review date to enable the defendant to receive legal advice and mediation. And it seems that this is likely to happen where a claim has been COVID case marked by the defendant, an accelerated possession claim. And on that note, I'm going to hand over to Nick, who is going to speak about legal advice and also going to put some flesh on the bones of the skeleton of the review stage, which we have excitedly referred to throughout. Thank you, Nick.
Thank you, Tom. Right, as Tom said, I'm going to start with a little bit about the legal advice and duty solicitor provisions that have been put in place. I appreciate that most people on this call are themselves legal advisors, but it is important to be aware of what's going on because it has been granted a new importance at the substantive hearing stage, which Evie will touch on slightly later. Broadly, the provisions or the overarching arrangements provide that non-means tested free legal advice will be provided at 2 points. The first is on the review date and the second is at the substantive hearing if there is one. How that interacts with COVID, and I'll particularly come back to the difficulties in doing this in the review date in a moment, is not made clear. The overarching arrangements contain a great deal of aspiration but not a tremendous amount of concrete information. It states that the legal aid agency by the 18th of September will have removed gaps in the existing coverage by issuing new contracts. And it says that all of the LAA contracts have been adjusted to allow the flexible provision of advice. Now this can include face-to-face advice, video advice, phone advice, or indeed the duty advisor calling a claimant back where necessary to address any call costs problems and in fact to manage demand. Not dissimilar, I think, to some telephone GP appointments that have now been put in place. So we're keeping it, sorry, to be clear, we're keeping everything on the timeline because it is helpful to have that timeline, we thought, as an easy reference point. It's not that you're missing out on any new slides, it's that the timeline helps keep everything in perspective because there are these new stages to be dealing with. So what is the review date, which you can see on our timeline? This is a new stage undertaken on paper where a judge effectively has a 5-minute review appointment without any of the parties present. This is the first date to be listed for both existing claims and new claims, as I think has been said, save where existing case management directions provide otherwise. In terms of the actual timeline, these review appointments are meant to take place at the very end of the judge's sitting day, and they're said to be an opportunity for the defendant to obtain free legal advice from the revised duty solicitor scheme, the claimant and defendant to reach some form of agreement with the help of the duty advisor, and possibly to facilitate negotiation and mediation under a new pilot, which again, Evie is going to come back to. Given that the parties aren't supposed to be present in court for this review appointment, query to the extent to which the duty advisor might be able to get hold of particularly defendants in order to give them their legal advice. If the claimant knows and has provided the court with a phone number or email address, perhaps. Otherwise, it looks like it might be dependent on the defendants to call in. We'll have to see how this works in practice. As I said, there's a lot of aspiration, but there's not a huge amount of clarity. The overall idea is effectively that the defendant finally gets his first piece of legal advice, the parties come to an agreement. If there is a consent order drawn up, then again, that's said to be provided to a court usher or member of staff. Given that the parties aren't there, I suppose that has to be digitally, and then the judge is available to make any consent orders. The idea, as has been noted by Evie and indeed by Tom, the idea of all of this is to try and reach a compromise. So one thing that comes out in the arrangements or overarching arrangements, whatever they're called, is that signing a consent order or agreeing an order for possession will not of itself mean that a tenant or borrower should be found intentionally homeless. There will be government guidance coming out on that point, but do pay attention to it. So in the run-up to the review date, 14 days before, the claimant must provide a bundle, ideally electronic, although the arrangements say paper is an acceptable substitute. Confirm that a copy of the bundle has been provided to the defendant as well as the court. Confirm that bundle includes all of the material, including enhanced information, and confirm that the claimant will be available during the review date. If there's agreement on that, then great. If no agreement and the documents are not in order, then the court can be expected to dismiss the claim with liberty to apply for reconsideration at an oral hearing, or it may give directions. The extent to which the court will take advantage of this opportunity to dismiss claims when papers aren't in order, we'll have to wait and see. If the documents are in order, then of course it proceeds to a substantive hearing if required. Sorry, let me just take a couple of questions. So there have been a couple of questions about the format of the bundle. I will come back at the end. I think that's easiest on that if there's time. So I will hand over now to Evie, who will pick up on the mediation scheme, which I've mentioned, and talk a bit about substantive hearings.
I won't cover the mediation scheme in any great detail. There's quite a lot on it in the overall arrangements. In essence, it's something that can happen after the review date and before the substantive hearing, but only if 3 conditions are met. Firstly, that at the review date, the defendant takes advice and the duty advisor takes the view that the case has reasonable prospects of settlement, but it's too challenging to be resolved at the review date, and that the claimant and defendant both agree that they will mediate within 7 days of the review date. The duty advisor may then refer the case to the new pilot scheme being run by the MOJ and the Ministry of Housing. And that pilot scheme will give priority to those cases which are COVID-19 case marked. It is one that will be facilitated by an independent professional who is going to be someone who could be a duty advisor and has done a bespoke training course in advance of carrying out the mediation. And it's totally voluntary and publicly funded. It will take place either by phone, video, or in person. The guidance isn't specific as to which option will be, how that will happen, whether it will be the parties choosing or whether the court will elect, and if the parties can't do one of those, then the option isn't available. But it's crucially limited also to 1 hour. What will happen if the parties do settle at that mediation is that an agreed order will be drafted by the mediator and signed by the parties. And then the mediator will provide the order to the court no later than 10 days after the mediation. At that point, the court will generally, we're told by the arrangements, vacate the substantive hearing. It's not clear whether that will automatically occur once the order is sent in, or whether that is something that will only happen once the judge has an opportunity to consider the order, and if the order is then approved and sealed. And I think I, for my part, have some reservations about this process and the process of agreeing orders and then them being rubber stamped, because there is lots of authority on the way in which agreed consent orders for possession claims can be made, especially where you've got a possession order being made, and whether there is jurisdiction for the court to make that order. So I think what I would say is it all sounds good, but have in mind the potential that agreed orders can be very tricky and knotty, and not to forget about those difficulties. If you don't land up going to mediation, or there is no settlement, then you've got your substantive hearing. That is more traditionally what we expect to have as a first hearing of a possession claim. It's a hearing that all parties must attend, and each claim is given a 15-minute slot. There is going to be additional time built in between the hearings for COVID-19 safety procedures, and the template that there is in the overall arrangement shows a typical day having 10 hearings. It will be treated in the same way as a first hearing of possession claim would be, i.e. the court will either decide the claim or give case management directions. And as with the review date, there will be free advice available on the date for the defendant. As Tom or Nick already alluded to, there's going to be a specific consideration given at that hearing to the question of adjournment, even if no application is actually made by the defendant. If there is a sign that there is no advice that has yet been made available to the defendant, and the consequences of the order may be serious in light of the pandemic. So a specific provision in the arrangements for adjournments, which is unique to the way that the court would have approached the question before, albeit that the arrangements do flag up that the court's jurisdiction to adjourn is limited by statute, and there may be cases where there is a limited or no discretion to be able to do that. So expressly, there is no attempt to curtail the statutory provisions which determine the court's powers. I think Nick is now going to explain in a little bit of detail what would happen if an order is made and how that can be enforced.
Thank you. Evie, could we have the next slide, please? Right, excellent. This is one of those no longer quite so fresh points that Tom referred to at the start, but for anyone who's not quite picked up on this, harmonisation of enforcement in both the High Court and the County Court is being, enforcement in the High Court and County Court is now being harmonised, or at least the notice provisions, notification requirements are from the 20th of September. There'll be a new CPR 83.8A, which will effectively provides that anyone or a landlord seeking to enforce an order for possession must give 14 days notice before a writ or warrant is executed. The new CPR prescribes the form in Practice Direction 83 to whom it must be addressed, all persons against whom the order was made and any other occupiers, and how said notice will be served. Insert it through a letterbox in a sealed transparent envelope, or attach it to the land or place stakes in the ground, methods with which we are all familiar. It applies to all claims other than sort of, I suppose, straight trespasser squatter claims, save for those trespassers or squatters who actually had permission to be there to start with. This is a sea change, as many of you will recognise from the previous position in the High Court, where all that was required was sufficient notice to allow the tenant to apply for relief, and the case law on that in Partridge and Gupta and Brooker and Wilson. We also see that there are to be new guidance, or we have been told in the overarching arrangements that there's going to be some new guidance about enforcement. This states first that parties are going to be encouraged to recognise, which is a rather nice phrasing, that transferring proceedings from the County Court to the High Court is not going to be of high priority. The guidance will say that no enforcement of possession orders should proceed where local lockdown measures are in place, in areas where public health risks could be greater. I'm not quite sure what that caveat is, because if there is a local lockdown in place, one assumes that the public health risk is already fairly high, and there are to be no evictions over Christmas, other than in the most serious cases. So that is eviction, and those are, again, the changes that we see. So after all of that procedural, or after all of those procedural changes, you might be forgiven for forgetting that notice periods have also changed. Again, these are not so fresh changes, so many of you will be across these. However, they have changed since the last webinar on this by some of our colleagues no more than a couple of weeks ago. The reason I put the legislation on there on the screen is because, frankly, trying to traipse through all of this is not a particularly easy task. Rather than simple amendments to the primary act, such as the Housing Act, we have the Coronavirus Act and its Schedule 29, which don't necessarily amend that primary legislation, but say that the legislation is to be read as if periods such as 2 weeks mean 4 weeks, or what have you. So you need to read both side by side to start with. You then get the amendment regulations, which both suspend some portions of Schedule 29 and amend other portions of Schedule 29. So again, you actually have to look at all three of these pieces of legislation together to get the full picture of where the notice provisions are. There have been a new Form 6A and a new Form 3 introduced. And again, we see the form regulations on the screen. This, as I said, well, I should say this is something of a hostage to fortune, because these do tend to change quite quickly. But that is the position as I understand it at the moment. If you're in the situation where, bearing in mind these changed on the 29th of August, you serve or tried to serve a notice, say on the 28th, which wouldn't have been served until after the 29th, you're in a tricky situation, and the newer notice periods are likely to apply. We simply don't have time to go through absolutely every new and revised notice period, but so I'll just look at Section 8 and Section 21, because those are the most common ones at the moment. Could we have the next slide, please, Evie? So, Section 8 notice periods. Again, the new notice provisions vary ground by ground. So, grounds 1 to 6, 9, 12, 13, 15, and 16, 6 months. Grounds 8, 10, and 11, which are the rent grounds, vary depending on whether it's less than 6 months or more than 6 months rent outstanding. As you can see, 7 and 7B is 3 months. Grounds 14A, which is domestic violence, 14ZA, indictable offence in riot, or 17, which is a tenancy granted on a false representation. That's 2 weeks notice. You don't see specific provisions for grounds 7A and 14, and those are, I think, bearing in mind the legislation is a bit of a mess, because actually the amendments to those in the Coronavirus Act, the schedule to the Coronavirus Act, are suspended by the amendment regulation. So those are back to the pre-Coronavirus Act position. Section 21 notices have notice period has been extended to 6 months, and the period of validity has been extended to 6 months. Otherwise, you'd have a 6-month notice period and a Section 21 notice that expires 6 months later. There are some general points of confusion to be aware of. Combining grounds is tricky. Again, it depends very much on the grounds. Commonly, a longer notice period will exclude a shorter one. There are some exceptions to that, because why make anything simple? And the rent arrears position can vary, again, between sort of type and tenure of tenancy. Some refer to at least 6 months rent, some more than 6 months rent, although those are largely similar. Again, there is some air between those two. So in all honesty, the notification periods are frankly tricky. Any particular case requires sitting down with a cold towel around your head and spending a lot of time with the legislation, but be aware that those pitfalls arise. So that's it from me, I think, and I'm handing over to either Tom or Evie. I've now lost track because we've been back and forth so much. Is it you, Tom?
I think we've now come to the end of our slides, and so there's a little bit of time to deal with some questions, unless Evie contradicts me. We've had a couple which have been put into the chat bar. The first one that I've identified is from Beverly Rayner, who's asked about whether, if a matter is currently stayed because it was issued prior to the 3rd of August, but the tenant is now paying by arrangement, if the case is not reactivated by the date in January, when does the time run out to ask for reactivation? And the answer to that, I think, is that, well, the claim will automatically be stayed again on the 21st of January if you haven't, by that stage, put in your reactivation notice. And what happens then is that you just need to make an application subsequently to lift the stay. And if you put in that application before the end of the interim period, i.e. before the period ending on the 28th of March, which is the period for which Practice Direction 55C is active, you will then also need to put in a reactivation notice. However, presumably at the moment, if you apply to lift the stay after the interim period ends and after Practice Direction 55C ceases to have effect, you won't need to put in a reactivation notice unless the interim period is extended or something else changes, which, given the way we've been going over the last few weeks and months, seems not impossible. The next question that I've identified is one from Richard Flavin, which is about reactivation notices. Richard has asked whether whether it's our view that a statement of truth is needed for the reactivation notice on the gov.uk website. Evie, are you okay to answer that one?
I am. I've just been trying to get the notice up, but I haven't yet managed. But I'm presuming that means it doesn't have a statement of truth on it. And my view is that's entirely correct, because there's no requirement in Practice Direction 55C for it to contain one, and CPR 22.1 specifies the categories of document which have to have a statement of truth. A notice, an unspecified notice, isn't caught by CPR 22 unless Practice Direction specifies otherwise, and Practice Direction 55C doesn't specify otherwise. So the answer is, if it isn't on the one on the gov.uk website, in that respect, that is, you're fine to follow that pro forma. I'm not going to say whether you're fine to follow it otherwise, as Tom has highlighted already. There are no doubt a number of ways in which it doesn't follow 55C, but it need not contain a statement of truth.
And the next question, I think, is whether it's likely, with the growing evidence of a second wave, that we'll get another extension of the period of the stay. I don't know what Nick and Evie think. I would say that nothing is impossible, but given that a lot of work has now been done to kickstart things in 5 days' time when the stay ends, it seems unlikely, especially given the way that the new arrangements have been set forward so that they're designed to be compatible with social distancing. As Evie's already explained, the parties will be offered a physical hearing, but it also contemplates that people will be able to appear remotely. So even if there is a second wave, I would have thought we can probably plough on with the overall arrangements in place. I don't know what Nick and Evie think.
Yes, I think that's what the impression that I've got of the arrangements, and the fact that the stay as originally envisaged was to allow for the fact that we were facing a truly unique situation where the courts didn't have the ability to deal with the pandemic, and we were in lockdown. I don't think I can foresee an extension at the moment.
I would probably agree with that, particularly given the extent they're going to try and get things like virtual hearings and those sorts of arrangements in place. I mean, the last 4 years have shown me that never to try and predict public events, so I'm a little bit reticent on that front, but I think the intention is to try and proceed with this as fully as possible.
Nick, there's been a question about what needs to go into the bundle which gets lodged before the review stage, and whether it's just the same documents that get sent in with the claim form. Does it need to be paginated? Do you have any comments on what you think the bundle needs to be and what it should contain, and whether it's paginated?
There isn't clear guidance on that in the OA, so it's one of those, I'm afraid, where it's probably going to have to be we're all going to have to try and feel our way a bit. My initial reaction is it's probably going to be more than just the claim form and the initial claim, because the court will want to see things like evidence of the impact of COVID, for example, or whether you want it to be, or whether parties want it to be COVID listed or not. So I don't think it is just the claim form. Effectively try and put it together as you would for, you know, if the matter were going to be decided on the review date. It probably won't be decided on the review date, or it almost certainly won't, but given that it could be, given that the court can dismiss the claim at that point if your papers aren't in order, I would put everything in the bundle, but you would need to make your case on that date at that point.
I would definitely agree with that. I think less is probably more. Ideally, you want to be dropping onto the judge's desk a complete paginated bundle with a good index and a contents page, which gives them everything they need to review the case at that stage and work out what to do with it.
Exactly.
Especially as we know what their files are like in certain courts like Central London. You don't want to be relying on the court file, do you?
No.
Another question about reactivation notices and their contents, Evie, and I think the question is saying we have inquired, will that suffice? What happens if you've made a number of attempts and the defendant does not respond to the inquiries? What do you think then?
I think you can say, you know, the claimant has no actual knowledge of the effect of the pandemic on the defendant. Setting out the steps that you've taken to find out what the position is, I don't see will harm at all. And it might be helpful in terms of COVID-19 case marking. For example, if your client is a private landlord and has suffered financial hardship as a result of the pandemic and not being able to get possession back. So I don't see what the problem is there in setting out that you've made various attempts and not been able to find out anything further.
And the next question is an interesting one about the possibility of agreed orders, meaning that a tenant becomes intentionally homeless. Nick, did you have a view on the significance of that?
Well, there is actually a specific line in the overarching arrangements that said that councils will be directed that agreeing an order for possession should not be taken as making one intentionally homeless. I can't get the paragraph number off the top of my head, but there is something definitely in there stating not to. And again, I think there's going to be more government guidance coming out on precisely that point.
Neatly cut across that. And another question about what happens to claims issued after the 3rd of August and whether they need reactivation notices. I think the answer to that is no, because they do not come within the scope of paragraph 2.1 of the practice direction. And so the requirement to provide reactivation notices is engaged. There are some other questions which have popped up in the chat box now. I'm just diving in. There's been an interesting question about commercial leases given the High Court's decision earlier today, and how likely it is that a court will agree to extend the stay to give the tenant the opportunity to pay. And I think it just, well, in such a case, the stay will have been lifted. So it's not a case that the court is going to be asked to extend the stay because the stay has been lifted, it no longer exists. If a tenant wanted to invite the court to stay a claim to give them more time to pay, then that's something they'd have to ask the court to do in the ordinary way. And it's difficult to speculate without knowing the facts, but it seemed to me that a judge would be quite reluctant to stay a claim to give a tenant time to pay. But who knows what the circumstances are going to be. We've also been asked whether there's going to be a further webinar on this topic, which I think is probably a bit above my pay grade. Does anyone else want to, I'm aware that it's now 5:30, so we should probably bring things to an end, unless anyone else has a question that they have a burning desire to answer.
Not a burning one. I see one about notices to quit served on personal representatives and public trustees. I'm afraid I just don't have that at my fingertips. It's rather unsurprisingly not one of the more common ones. So that one is a sit down and wrap the cold towel around your head to check. I'm afraid I don't have that off the top of my head.
There's a question about where to find the wording of grounds, and that can be located, I think, just in the Act itself, or by doing some judicious Googling. I think that probably. Oh, someone has argued whether has asked whether the slides are going to be circulated, which I understand they are going to be tomorrow.
And they'll also be uploaded onto our website, as well as the recording of this webinar. So you can find these slides as well as the ones from the last version of this webinar with Brooklyn, Miriam Zietler and Kimberly Zier also on our website. And I think otherwise it's probably time to bring things to a close, given that we have unfortunately, and we're sorry to have done so, run on by a bit of time, but given that there was so much to cover in light of the overall arrangements, I hope you forgive us for doing so. Thank you all for joining and for the many interesting questions that you raised this afternoon. Goodbye.
Good luck.
Okay. Good luck indeed.